I just also want to mention a number of documents. We've received a number of documents which I just want to mention. One was highlighted this morning, which was Mr. Cameron's reference to a court judgment, the A1 judgment. There's also been correspondence from from Natural England, which consists of an email with a couple of attachments, which is confirming their position and making some comments about conditions. And there's also been a short letter from National Highways, again just confirming their position with regards to the inquiry. So those three documents, the panel of myself and Mr. Clegg, we've accepted those, and they will in time be published on the website. On the judgment, I wonder whether Mr. Cameron, you could just remind me which paragraph in particular you're referring to in the A1 judgment.
61, I think, sir. I'll just check my notes.
Paragraph 61. Thank you, Mr. Cameron. Okay. In that case, I shall now hand over to Mr. Clegg for the first of our roundtable sessions.
So can I just, you asked for paper copies of the works and land plans, and I can hand them in.
Thank you.
Two sets.
Thank you very much.
Thanks, Jeff.
Right, moving on now then to the first of the two roundtables scheduled for this afternoon, just to cover the position of proposed modifications, I should say, to the draft order. I'd just like to check who's likely to be participating from the various parties, first of all. Mr. Cameron, on your side, is it your front bench, as it were?
Yes, on this, and on next to Mr. Henderson is Ms. Redman, who's a partner from Womble Bond Dickinson, who will, and who's my instructing solicitor.
Right. Is that Redman READ or RED?
It's REDMAN.
Thank you. And going around the table,
I'm not sure your microphone is working. Is it switched on? Is it the switch at the back? I don't know if that's...
Is that working now?
That's it.
Much better, yes.
Thank you.
Probably because I had mine still switched on, but I turned it off now.
So Mr. Robkin, right, it's yourself and Mr. Kelly, or is it both of you?
Yes, I mean, I don't anticipate we will be saying anything in this session, but if we need to, then it will be one of the two of us.
Okay, thanks. And two new participants here, I think.
Good morning. So I don't have a microphone. I'm assuming you can hear me. I don't know whether I need one for the purposes of the live stream.
I'm wondering whether
You do for the...
I won't be participating, so why don't you take my microphone?
Thank you. There is also a roaming one if we need one.
So that sounds like that is working. My name is Hereward Philpott, King's Counsel. I appear together with Ms. Stephanie Bruce Smith of Counsel. We're instructed by Michelle Vass, a partner at Denton's Solicitors. We're here on behalf of Claire Hall, a part of Cambridge University. We don't anticipate that we will be participating in the first of your roundtable sessions on the amendments to the order, but we are intending to speak in relation to the environmental impact assessment item. So I'm happy to surrender my microphone for the purposes of the other roundtable session, if that helps.
Right. Well, let's see how we go on. Mr. Parker, anybody on your table? Okay. Is there anybody else in the room who's intending to participate in the roundtable discussion now? Right, I think we've got participants we need at the tables then. Thank you. The first thing I wanted to check, Mr. Cameron, was just the publicity and to what extent there was awareness of the modifications. My understanding is that there's 2 rounds of proposed modifications. There was a set proposed, I think, just before the pre-inquiry meeting, which was referred to then, and then a very recent set which had been trailed but hadn't been submitted until last week. Am I right on that?
That is right, sir.
So the initial sets were mentioned in the pre-inquiry meeting. They were covered in the pre-inquiry meeting note, and they were on the website at an early stage. Although we've only just received the further proposed modifications, has anything else been done to make parties aware? Mr. Redmond, I think you're saying it doesn't matter. You can go direct in a round table.
Yes, that nothing further has been done. I believe they are now on the website, but
Yes.
beyond that, nothing further has been done.
And is the same the position with the changes to the book of reference? Because I think they're just in part of the second phase of modifications, if I'm right.
So we did say that we would update the book of reference, I think, at the pre-inquiry
You did,
meeting.
but it hadn't happened then, I don't think.
It hadn't happened, and so this is
This is recent as well.
This is as of the August, I think it was updated, sir, and that's gone in.
But that's just coming to us now.
Just coming now.
But if it was done in August, has anybody else been made aware of it, or is it
No.
the same position as with
Same
the
position.
order? Okay, thanks. And sorry, Mr. Cameron.
Well, can I just add that what we were going to propose, although it's a matter for you, is that you might wish to hold another roundtable session on the order towards the end of the inquiry, which would give all participants, particularly the applicant, an opportunity to propose any further changes, and that once the programme is in a slightly more certain state, would be advertised on the programme, and that any documents or any changes to the order that arise as a result of this discussion would go on the website, that people would know that they could come and contribute at a later stage in the inquiry through advertisement on the website, not suggesting any other advertisement, but there would then be notice. It's a matter for you, sir, of course, whether you decide to have another round table, but it might be convenient to have one towards the end of the inquiry so that before the inquiry closes, you have the final word on the draft order.
Do you have in mind the possibility of further proposed changes?
There's nothing that's particularly in mind at the moment, but I do have in mind that there are protective provisions for a number of undertakers,
Yes.
and a few changes made in response to representations made. We don't anticipate any others, but we'd like to just leave open the door.
Just
to
in
that
case.
possibility. It
Yeah.
is a just in case, but that just in case also enables a further round table to be advertised so that anybody could, and by advertised I mean put up on the website.
Yes.
So anybody can come along.
Right, can you leave that with myself and Mr. Underwood, and we'll discuss that possibility. And then the third area that I wanted to come to was the works and land plans. Well, I don't think I've seen any reference to changes there, but given the book of reference and the order, which I just wanted to be absolutely clear that they remain as originally submitted.
Yes, sir, there's no changes proposed to the land or works plans.
Okay. Well, I think the next thing then I wanted to do was just to go through, as I understand it, the areas where the changes are made. I want to get an understanding of what type of changes are being proposed. And I think what we were told initially in the first document that came in that set out the changes was that split them in, I think, three categories. Although, if we want to see them all in one place, there's I think it's core document CD1 02F sets them out in two groups.
So CD1 02F has got the schedule of changes, so that includes every change.
That's right.
The first version changes are at the back of the
They're at the
document,
back,
and
yes.
the newer version is at the front of the document. I believe a new CD has also been added, which is CD1 02G, which is a comparison of the original order versus the most recent changes. So that does include all of the changes made to
yes.
date, and then there are two other versions depending on when they were submitted.
Can we go to the initial set of changes first, the ones that are at the back of the document with suffix F? And I think the June changes are on pages 14 to 39 of that document. Now, I think what was said about those changes when the original schedule came in was that there were, in effect, three types of change. And the first was, I just want to check whether my understanding of this is correct and whether any other parties have any comments on them. The first, I think, was said to be typographical corrections. And then there were references to plot updates, so I presume that perhaps some plot references were found to be incorrect or not marrying up with the works and land plans. And then thirdly, there was a reference to protective provisions. Now, does that cover everything on the first round of changes?
Yes, so I think broadly that's correct. The typographical changes consist of a number of different changes,
yes.
which I'm happy to go into in more detail if you'd like me to. The plot updates are, as you say, just corrections in terms of marrying up the relevant plots and
making sure everything's consistent.
Exactly, yes. And then the third update was, as at, I think the first document was submitted in June, as at June we had made some progress with undertakers in terms of protective provisions, and where we had made progress at that stage, those were included where those had been agreed. So yes, those were broadly speaking the three types of changes which were made.
Right, I think I'm happy with your response in terms of the plot updates. They're simply corrections for consistency. In terms of the typographical alterations, is there anything substantive in there, or is it simply errors in presentation?
So I think it would be the latter more than anything. It's capital letters,
yes.
corrections of definitions, insertions of commas, consistency in wording.
In terms of changing what the order is about?
There's no substantive changes other than to the protective provisions at version 1.
Right, okay, well let's move on to the protective provisions then in round 1. And could you, just for the benefit of everybody's here, could you just outline what was involved there?
Yes, sir. In summary, these were changes which were agreed at that point with the relevant statutory undertakers.
Yes.
In respect of some changes in relation to Cadent Gas Limited, there was a new provision which dealt with whether the protective provisions would take precedence over some of the schedules in the order. So in essence, the Schedule 12, which is the cadent protective provisions, now takes precedent over paragraph 2 of Schedule 11, which is apparatus and rights of statutory undertakers in stocked up streets. So it's a clarification point more than anything to make sure that the specific provisions for cadent take precedence for cadent.
Right. Were there any others at that stage?
There were, but some of them were quite minor, sir. So
Yes.
there was an amendment to ensure that the undertaker entered into deeds of variations rather than just consent or providing just consent. And some more changes have been made subsequently
Yeah.
to that in version 2, which I can deal with in due course.
So essentially detailed points concerning the protective provisions.
Correct, yeah.
And was there anything else anticipated at that stage, or just those 3 areas that we've talked about?
Yes, and then there was some changes for the Environment Agency in the version 1 changes as well.
Yes.
So there were, again, fairly minor changes, I would say, at that stage, changing some specific wording as requested by the Environment Agency. Nothing hugely significant, I don't think so, at that stage.
Okay. Can I just check with other parties in the room whether, having heard what Ms Redmond said about the proposed modifications first put forward in June, that there are any comments or questions about those? No. Okay, thank you. So then we come to the second round of changes, Ms Redmond, in September. And there, I think on pages 3 through to 39 of CD102F. Now, I've got to note that there are 2 articles that are proposed for removal. I think there are changes proposed to a third. Is there anything else proposed in this round as well?
No, those are the 3 substantive changes.
Right. Now, I think from what I've seen so far, they do seem to be more substantial than the changes that went before.
Correct. So apologies, there are also some further changes to the protective provisions.
Right, yeah. So changes to the articles and the protective provisions.
Yes.
Couldn't we take them one at a time? I want to make sure that, particularly if articles are going out, that Mr Underwood and myself do understand
Yes.
the implications of that. The first one I've got a note of is Article 39.
Yes, sir. So this is removal of Article 39, which is maintenance of approved works.
Yes.
The purpose of Article 39 is that where the busway is not maintained in the condition that it was approved,
Yes.
and that impairs its safe operation, the applicant can be guilty of an offence and
Yes.
receive a fine limited to level 3 on the standard scale. That article was originally included because it was also included in the Cambridgeshire Guided Busway Order 2005,
So it was following on from a previous case?
a previous precedent
Yes, yeah.
order.
Yes.
The applicant has reviewed all of the articles within the order which contain criminal offences as part of its justice impact test. The justice impact test is a Ministry of Justice tool,
Yes.
and it provides an assessment of the impacts on the civil and criminal justice system of the new offences created
Yes.
by the order. And The applicant has therefore looked at those new offences to determine whether they are all necessary to include in the order where new offences are created. As part of that test, the applicant is required to submit a form in relation to those new offences.
Yes.
And it deals with the costs of how those new offences will be dealt with, essentially. So on the applicant's review, it considered that it was appropriate to remove Article 39. In the first instance, it's felt that Article 39 doesn't serve any purpose, and that's because it requires a specified authority to approve works, plant or equipment which is part of the busway, and that approval can only be given if regulations have been made under Section 41 of the Transport Works Act 1992, and no such regulations have been made, and the applicant is not aware of any intention to make those regulations. So at the moment, those regulations haven't been brought into force under Section 41.
Right, so even if you felt that there was some merit in Article 39, you couldn't proceed with action under it, is that so?
Not at the moment,
Yes.
not unless regulations were made under it. In addition, Section 41 doesn't set out the entity to be specified,
Yes.
which would approve the works. So it's not known whether that would be, for example, the Health and Safety Executive, which is the entity which is currently named in the article, or, for example, the Office of Rail and Road. At the moment, as far as we understand, the Health and Safety Executive's functions do not currently include approving works,
Yeah.
and therefore it was felt that it wasn't necessary or appropriate to include it because, as a matter of law, whether or not Article 39 is included in the order, Section 41 would apply. And any regulations which were made in the future under Section 41 wouldn't necessarily limit the fine to level 3. And in addition, the busway is already subject to health and safety laws.
Oh, that's what I wanted to ask you. If Article 39 is removed and there was an issue with maintenance and a need for action to be taken, whether there was another way of achieving that.
So at the moment, the busway would be subject to health and safety laws, so the Health and Safety at Work Act 1974.
Yeah.
And so a breach of duty under that legislation amounts to a criminal offence with an unlimited fine. So under the article, it is limited to level 3,
Yes.
but if the article is not included, it's potentially unlimited under both Section 41 and the health and safety legislation.
So are you saying that there's an argument that in effect Article 39 was duplication?
Not duplication in the sense that it does something different and the
Yes.
regulations aren't yet in force, but there is already a
But in
mechanism.
terms of its aim?
There is a mechanism
For it, yeah.
to deal with this under the health and safety legislation.
It's not leaving a gap, in other words.
No, sir.
Okay, thank you for that.
So,
Yes, of course, yeah.
Just by way of explanation, you mentioned that the alternative would be under the Health and Safety at Work Act. I'm not so familiar with that. Would that mean that there'd be a difference in terms of how the HSE might look at something depending on who and what the any particular event arising from a sort of lack of maintenance would be? For example, if it's a member of the public as opposed to a bus driver.
My understanding, sir, is that it's treated in the same way. So whether it is an employee on operating the busway or whether it's a member of the public, the offence can still be created under the Health and Safety at Work Act.
Okay, thank you.
And then the same proposal in respect of Article, I think it's 55, that to be removed from the draft order as well. Could you just outline that as well, Ms Redmond, please?
Yes, sir. So Article 55 is proposed to be removed. The purpose of Article 55 was to disapply the National Trust covenants over the land which was affected by the busway, as otherwise those covenants would prevent the construction and operation of the busway.
Yes.
However, agreement has been reached with National Trust, and you mentioned earlier, sir, that they had withdrawn their objection.
Yes.
And agreement has been reached with National Trust, and the agreement that has been reached deals with essentially a release of the relevant covenants so that the busway can be constructed and operated without a breach of those covenants. And that was completed on the 11th of September.
And is that a formal agreement rather than just the parties agreeing?
Yes, it is a formal agreement.
So again, there is an alternative means of achieving the end that's sought.
Yes, exactly, sir.
And then the third article is it Article 5?
Yes, it's Article 5.
And this one is, the proposal here is not to remove it, but to, I think, alter parts of Article 5, isn't it?
There is a deletion of one of the paragraphs and some sort of hanging text that refers to that paragraph. So it's deletion of paragraph 8 of Article 5.
Right, and what, can you just explain what the
Yes,
intent
sir.
behind that is?
It may help to have Article 5 in front of you as I go through it, sir.
Right, let me just find it. Sorry, I'm there now, Ms Redmond.
Thank you, sir. So Article 5 is the power to construct and maintain works.
Yes.
As we discussed earlier, sir, the inspectors requested a description of development.
Yes.
And that was provided by way of letter dated the 8th of July, and that's CD 252301.
Yeah.
And within that was the description of development, which is CD 252302. We discussed this morning how that comes about in terms of Section 92A of the Town and Country Planning Act 1990.
Yeah.
What we have done as part of that exercise is also to review what the order is authorising, because that will lead to the whatever is granted deemed planning. And so if we just go through Article 5 and then I'll explain the change. So Article 5.1 authorises the scheduled works. That is essentially the busway. And then jumping over then to paragraph 3. Paragraph 3 authorises the associated works in Schedule 2. And then paragraph 4 authorises the associated works in Schedule 7. And then paragraph 5 authorises associated works which are listed there in paragraph 5. You'll see them listed A to M.
Such as stops, platforms, etc.
Correct.
Yeah.
And then paragraph 6 authorises, is much wider, it authorises other works, essentially which may have been missed out in all of the preceding works. And what paragraph 8 does is it limits the power to undertake works listed particularly at paragraphs 5, A to M, and paragraph 6. So the limitation that's in the article is that you can only carry out those works at paragraph 5, A to M, and at paragraph 6 on land and for the purposes specified in the relevant schedule.
Right.
And the concern, sir, was that that was unduly restrictive for the purposes of description of development, given that the schedules themselves have been prepared for the purposes of acquisition of land or rights or temporary use of land. And therefore it's considered that that subjectivity should be deleted, and that's why paragraph 8 has been deleted, and the words subject to paragraph 8 in paragraphs 5 and 6, to provide essentially a broader power for undertaking the development as set out in the article. So this does widen the power. However, there are conditions which would require the deemed planning to be carried out in accordance with the relevant plans, and those plans are CD 1601 to CD 1607. And so there is a constraint in terms of what can be carried out and where it can be carried out, but it doesn't constrain it in the way that the schedules do to specific works on specific plots.
But isn't the intention, Ms Redmond, to carry out specific works in specific locations to construct the scheme overall?
Yes, it is, but there does need to be, I think, some flexibility around that, particularly if you look at some of the things listed in A to M. They can be quite broad, and certainly the other power is very broad in terms of if you need drainage, for example,
yes,
which may not have been included, or signs which may not have been included for a specific plot.
But in terms of the main works involved, they're tied to the plan, so it's not giving scope to make substantial changes. Is that right?
Yes, that's correct, because they're tied to the planet, the conditions tie them to the specific drawings which show where the works are and the location of the works and the specific works. And in addition, the actual busway itself is limited, because that is limited under Article 5.2, which provides limits of deviation for the busway works specifically.
Yes.
So these are only elements of the works which do not comprise the busway. And then, in any event, they would be limited by what's on the planning drawings, which are secured in the conditions.
Yes, but secured separately. There's not a cross-reference from the order to them, is there?
No, they're secured separately,
yes,
through the conditions.
Okay.
So if I could
Yes,
just
Mr. Cameron, please.
add on that, if one mine, the paragraph numbers seem to have changed, so I may have got the paragraph numbers, but the powers are not unlimited. They're to carry out and maintain, for example, in the such other works, which I think is 6, as may be necessary or expedient for the purposes of or purposes ancillary to the construction of the scheduled works. So it has that limitation, and the scheduled works are defined, and you'll find that
Yes, that's true.
definition.
I suppose the question is what's the interpretation of necessary or expedient?
Yes, it would be, but it imposes a limitation which is within the order itself, and the scheduled works are defined in Article 2, and they are the works specified in Schedule 1, which is the list that you have in Schedule 1
Yes.
in the normal way.
Just help me understand a bit better. You mentioned, by way of example, signs and drainage, Ms. Redmond. Can you give me just an illustration of what sort of works you wouldn't be able to do in the way it was originally drafted, and what you would be able to do if subparagraph 8's removed? Just to give, so maybe using signs and so in terms of the reference to the schedules in subparagraph 8 at the moment, how would that affect what signs you could put up on a particular part?
I don't have a specific example. I suppose if you turn to, it might be helpful to look at one of the schedules so you can see the way they are specified in terms of the plots. So if you turn to example to Schedule 2, you can see just on the, if you turn.
So what page is it on?
I haven't got the PDF in front of me.
Might be 46 in G, in 02G it's 46. Sorry, I haven't got mine.
Yep, Schedule 2, I've got that, thank you.
Yeah. So if you look at the first line there, it's quite specific in terms of saying you can only undertake drainage and basin retention, pond landscaping and environmental mitigation on the particular plot that's mentioned there, 10021. And I suppose what I'm saying is my concern is that is potentially quite restrictive if there may be other works which you might need to undertake on those plot which would otherwise fall either within A to M or within the broad paragraph 6, the other works as may be necessary. So it's very, very precise, which could have a sort of unnecessary. So, for example, you've got a new bridleway connection just slightly further down that list. You may need drainage in connection with that new bridleway connection or something similar. And so I suppose I just didn't want it to be too narrow in terms of granting powers for the actual construction of the works, as opposed to, this has been drafted very much from a acquisition of land perspective.
But in that example you've just given us in Schedule 2, Ms. Redmond, if we go to that first item again, that specifies the purpose for which the land may be acquired. So it doesn't anticipate anything else happening.
I suppose it's how precise my concern was if it was overly precise, that might then limit what it is required for.
But given the way it's written, how could you introduce something else into that when you've got that heading at the top of column 3?
Well, I suppose it's a question of trying to read it, isn't it, with what is provided under Article 5. But my concern is that some of the wording in Article 5 is more specific than perhaps it is in row 3, and that could cause a conflict or some uncertainty as to how the two relate to one another.
I just wonder if the proposed amendment is internally consistent with Schedule 2.
Yeah, is there an issue given that Article 5 is about works and Schedule 2 is obviously listing purposes for land acquisition, that things are getting a bit... You're using a land acquisition schedule
That was my concern.
to define or not to define works. Is there an issue there? I'm not sure.
Yeah, that was my concern, that the two didn't necessarily correlate,
Yes.
and that therefore it might unnecessarily restrict what could be done without revisiting Schedule 2 and making that much broader, which you wouldn't wish to do. So it was just to try and clarify, I suppose, that those other elements could be undertaken more broadly.
Okay.
I suppose what's going through my head is, again, the flip side of that, is there something that if you take that out of Article 5, would that effectively allow you to do things that you haven't actually got, the order hasn't actually given you permission to acquire land for? If I've understood that correctly. Because Schedule 2 is saying this is your order setting out what you want to acquire, isn't it? And Schedule 2, along with other schedules, is setting out what you want, what its purpose is for.
I think so. On that, there's in Article 5, a distinction is drawn between scheduled works, which are those in Schedule 1, which are the main work. Schedule 2 is ancillary. And this restriction, which is imposed by paragraph 8, is imposed on ancillary works, Schedule 2, land acquired for ancillary works, Schedule 7, new rights, Schedule 9, temporary possession, and those restrictions are not applied in relation to the scheduled works.
Right, okay.
And so it's actually trying to achieve a degree of consistency, but you're right, sir, the difference between Article 5 is power to construct and maintain works, and Schedule 2 is what you're allowed to acquire ancillary land for. And this isn't some attempt to say, oh, can we do all sorts of things which we didn't acquire the land for.
Yeah.
It's just to make sure that we're not prevented from doing something in that list on part of the ancillary land, because we're allowed to do it on the main scheduled works land.
Okay. Anything else, Jeff?
No.
Yeah. Okay. Thank you, Ms. Redmond. Did you also say that there was something further in the second round to do with protective provisions?
Yes, sir. So there were some further changes made with Cadent gas. One of the main changes in relation to Cadent gas is it feels like a very minor change, but it's a must to a may. I'll see if I can find the reference. Sorry, sir, bear with me.
Maybe, don't want to go to the wrong place, but if you go to paragraph 28 in part 4, which you might find on page 82, and there's 28, again, my paragraph numbering's gone wrong, but it's page 82 of the PDF, and that's where you can see a must is crossed out and replaced with a may.
Yes, that's right. So it's paragraph 28(3). Cadent were concerned that they wouldn't be required to provide or essentially to have to undertake, for example, compulsory purchase to afford other rights or facilities because of the process which they are required to go through, if that is required. And so that was changed to a may, so that there is no requirement on them to do so rather than a must.
Right, so that's at their request.
That's at their request. All of these changes are agreed with Cadent.
Yes.
The other main thing that they requested was, you can see at paragraph 30, where the amount of days that Cadent are given to review a plan of any of the works undertaken has been increased from 28 days to 56 days.
Yeah.
And then at paragraph 36, certain disputes have been removed from dealing with them by arbitration.
Yes. So you get onto quite detailed points there in terms of Cadent.
Yes.
Yeah.
The rest were more like minor typographical changes.
Yes.
But those are the main changes from Cadent. And then there were a few other changes from the Environment Agency that, again, have been agreed with the Environment Agency. I think it's part 7 of the order. So on mine is page 99, but you may be 98, 97.
97 it begins, 90 and 98.
So there have been some changes to the definitions, again at at the Environment Agency's request. And I think one of the key changes is amending the requirements around when the EA's approval is deemed to be given. So that's paragraph 68, 3b. Essentially, the Environment Agency were concerned that there would be no deemed approval of any works.
Yeah.
And so that is essentially now a deemed refusal rather than a deemed approval.
Again, at their request.
Yes, at their request, yes. And then the next main change is in relation to paragraph 77.
We're still in part 7, are we?
Yes. And that's the way in which the undertaker will indemnify the Environment Agency. And that's been specifically agreed as well with the Environment Agency.
Yeah.
You can see there's been a replacement of the previous
Yes.
paragraph 77 to a much more specific clause.
does that essentially cover it in terms of
Those are
protective
the
provision?
main changes to the protective
Yeah.
provisions, yes.
Again, can I check with other parties whether there are any comments on that round of proposed changes to the order? Yes, Mr. Fulker.
Sir, I hadn't anticipated that we would be commenting on the changes, but I confess we had not been aware until now that there had been changes introduced at the end of last week. So I've been following the discussion, in particular
Yes.
in relation to Article 5. It's helpful to have that explained. What I would like to do is to reserve my position about the implications of that, both in terms of whether it has implications for any of the works that might be permitted on land that affects my client,
Yes.
but also as to whether any of the restrictions that were previously built into the scope of works authorised by Article 5 has any implications for the assumptions made for the purposes of environmental impact assessment. I identify those as the two main headings that I would like to have an opportunity to consider,
Yes.
having heard the explanation, but I don't think I can help by speculating at this stage. We just need to take those away and check.
Well, you'll have heard what Mr. Cameron said about the possibility of revisiting the proposed modifications
Indeed.
later on.
And so if we've got particular points, we'd be happy to raise those at a later stage. I just flag now that we haven't hitherto been aware of and therefore considered any
Yes.
implications of those changes.
Okay. Well, all the details of them are now on the website, so you should be able
Indeed.
to follow those through.
And it's been helpful to hear Ms Redmond's explanation. Thank you.
Thanks. What I want to do now, Ms Redmond, is come to the book of reference. And I'll just find my copy. I think the document I'm in is CD 11302, which is a schedule of changes. And I think the first thing I wanted to check was that I think the covering letter, which refers to this, it's a letter of the 12th of September, it refers to a refresh of the book of reference, which you mentioned earlier, which I think took place on or about the 8th of August. But the covering letter's the 12th of September. I just wanted to check whether exactly what the correct date is, whether that is the latest version.
Yes, so that is the 8th of August is the latest version. Essentially, the refresh was undertaken, and I think we'd anticipated submitting the refresh earlier, but there was a decision taken to delay submitting it in case anything else came out of evidence which needed correcting in the book of reference, so that it could just be submitted in rather than multiple versions.
Yes.
So the 8th of August is correct. And I think, sir, we've said that we would submit or undertake another refresh of the book of reference at the end of the inquiry.
Right, so given what you've just said, am I right in thinking then that that schedule of changes at 1302, that is consistent with the refreshed book of reference?
Correct.
I mean, the changes in the schedule, they look to be quite detailed. Is there anything of particular significance that our attention needs to be drawn to?
No, sir. In essence, there are two changes, really, or two sort of landowner changes, if you describe them in that way. One is a change from Dry Drayton Estate Limited to PX Land.
Yeah.
And the same with the mortgagee, the change to PX Land. That's one change.
Yes.
And the second change is including Aquila Investments with rights. And I don't know if you recall, sir, but I believe this was dealt with in the...
There's been early correspondence on Aquila.
Correct.
Because I think they were overlooked, weren't they, at an earlier
That's
stage,
correct.
or they weren't, or the applicant wasn't aware of them.
Yes, that's
I think
correct.
They're a wholly owned subsidiary of St John's College. St John's College and Aquila are represented by the same agent,
Yeah.
drawn to the attention, and then Aquila, I think from memory, wrote in to say
Yes.
that they didn't take any point on the fact they hadn't been named because they knew about it
They knew
through
about it anyway.
St John's College.
Yes. So what this schedule does is just update with the most recent knowledge. Okay. So that in effect is it, just those two
Yes, just those
two areas of change.
two areas of change, yes.
Any comments on the Book of Reference changes? Right, thank you, Ms Redmond. Is there anything else at all that we need to be aware of in terms of the Book of Reference or the proposed order? No.
No, sir, I think at the moment, as Mr Cameron said, we're not anticipating further changes
Yeah.
to the order, but would like to reserve the position in case any changes are required.
Of course, yes. Well, we will consider that suggestion, particularly bearing in mind the point made by Mr Philpott. Thank you for talking it through, Ms Redmond. So that concludes the roundtable and the discussion on the potential proposed modifications to the draft order. Thank you.
We'll move straight on to the roundtable session. Are you happy with moving straight on?
Yes. Yeah.
As Mr Clinton, if I could just sort of clarify who's taking part or intending to take part in this, I'm sure there'll be some people who've already spoken. So can I just confirm who will be joining us from the applicant side, Mr Cameron?
Mr Saunders, who's just about to sit down, who's the overall environmental witness, you'll recall, sir, and we've also got Mr Southern, who's the flood risk witness. But we'll, rather like with the last round table, I'll be making some contributions, Mr Henderson might be making some contributions, we'll see who's most appropriate.
Thank you, Mr Cameron. To Cambridge City Council and South Cambridgeshire District Council,
We're not anticipating on participating. Thank you.
I know, Mr Philpott, you said you would
Yes.
be participating.
And so I don't have my planning witness, Miss Wilson, today. She had a pre-existing professional commitment and was unable to attend, so it'll just be me.
Okay, thank you. Is there anybody else? I can't see any hands up. Thank you. The first item, the second item on the agenda was the composition of the environmental statement, and I think by that I just want to, if I can start by asking the applicant, just provide a confirmation of the components of the environmental statement, which, as I think I understand it, from November 2024, there was the environmental statement which was accompanied by technical reports. There was an addendum in June of 2025 and a second addendum and clarifications in July 2025, which I think was prepared in response to some of Claire Hall's observations. So if we can just start with the applicant, just to give us a rundown and confirm what the position is with the composition, please.
Certainly. Can you hear me? Oh, right. Used to that straight away. Can you hear me now?
Yeah.
Yes. Okay. Right. Yes. As you say, the main environmental statement was CD1 1001. So that was a document that brought together all the various environmental components, but also set out alternatives and proposed scheme, etc. There was also the non-technical summary, as required by the rules. That was CD 109. Just one point on that environmental statement was it was quite a succinct document, and it drew very heavily on the regulations that dealt very much with likely significant effects and focused on that as per the rules, regulations. Then it was supported by various appendices. There was a mitigation register that contained, I think, 50 commitments to mitigation. There was a statement of competence, as is a requirement to go through the EIA team effectively and set out their credentials. CD1 1004 was Appendix ES3, that dealt with cumulative developments list, so all the other projects that were taken into account for the assessment. CD1 1005, that had the scoping report and the opinion from the Department for Transport. That scoping opinion had 107 points that were made, and so the team went through those and either agreed with them or noted them. There was one occasion which one was rejected out of the 107, and that's in the register there, and that was a request to, I think, comply with a standard that wouldn't be the correct standard to use. But that aside, so that was the scoping opinion and the response in that appendix. And then, as you say, there were two addendums. There was the June 2025 one, which was CD1 1006, and then there was CD 1007, and that was addendum 2 with some clarifications, and that was the response to the note to yourselves from Clare Hall. And then just to finish off, there were a range of what we term Volume 2 technical reports. There were quite a lot of them, but they ran through 12 topic areas such as acoustics, air quality, and finished off with CD 11.14.04. That was a technical note, but the whole range of those is presented in the environmental statement. So that's the sort of component parts of the environmental statement and the addendums.
And just for clarification, Mr. Saunders, the technical reports, they're all contemporary with the first issue of the ES,
yes.
Is that right?
Yes, that's right.
So
yeah.
Any additional information was contained within the addendums as they were issued, is that correct?
That's right, yes. The only, as I say, just the addendums for June 2025 and July 2025, they didn't have anything additional. Freestanding. Yeah.
Thank you. Has anybody got? That was useful just to get that, get those points confirmed. Is there anything anybody else wants to ask about the composition of the environmental statement, how it's been made up?
So no, that reflects our understanding of what is labelled as the environmental statement for these purposes.
Thank you, Mr. Philpott. In that case, I think we can now move on to item 3, I've written it down as the adequacy of the applicant's environmental statement and the EIA process in a number of different aspects. Now, these are largely, I think, in response to comments that were made by Clare Hall. I think both in a representation you made to the panel, but also I think that in a number of proofs there is reference worded in different ways, I think, about whether the environmental statement was adequate. As I mentioned, I think in the, or I asked Mrs. Vincent to mention in the covering note, my intention today wasn't to go into sort of fine detail about the technical aspects, because on each of these we will be having a detailed session where there will be formal evidence presented and formally examined in one shape or form. So that's just to sort of say that I don't really want to get into that level of detail today if we can avoid it. However, I think what would be helpful is to perhaps go through those bullet points I've put down there. Just before I do, Mr. Philpott, the 5 bullet points I've put down there, does that effectively represent what Clare Hall consider are deficiencies.
So the headings that you have identified, with one caveat that I'll come to, do embrace, in one way or another, the points we've raised. That they reflect the way that these items were ordered in our post-PIM note, which is CD 952. As we'll come to when we deal with the individual items, under some of those headings, there are issues raised which might not immediately seem to relate to the item, but they do. So, for example, in relation to flood risk, we raised the point that the landscape and visual implications of the bridge over Bin Brook didn't seem to have been properly considered or assessed anywhere. So that comes under the heading of flooding because it fell under the sort of consideration of the Bin Brook issue. But it is encapsulated within our note under that heading. So we've assumed that it embraces points that we have raised. The only other caveat that I wanted to note was that in relation to noise, the heading in the agenda item is operational noise, and the note that was put in CD 952 referred to the acknowledgement by the applicant as part of its own assessment that operational impacts could exceed impact thresholds. But it's evident, I hope, from the statement of case and the evidence of Mr. Blacklock that the concern about the adequacy of the way that noise has been assessed and approached in the ES embraces both construction noise and operational noise, and indeed construction vibration. So the way that the CD 952 introduced this referred to an acknowledgement by the applicant in relation to operational impacts, but that wasn't intended to confine the concerns about the adequacy of what had been assessed to those types of noise impact only. So that's a clarification, but I don't think that would come as a surprise when anyone has read the noise evidence that we've put in, which deals with those matters.
Yeah, and I'm right in thinking that Mr. Blacklock isn't raising an issue about operational vibration.
No, it's construction vibration and construction and operational noise.
Okay, well, thank you for those points. I think probably what would be helpful is if you can briefly just set out, again, without getting into the sort of technical detail, what you think are the issues around alternatives, and then I'll ask the applicant to sort of respond to that. Mr. Cameron, you want to ask a question?
I don't. I will respond in due course, sir, but I just wanted to check, if I can, with you, that when you had the heading adequacy of the environmental statement, one can regard adequacy in a number of different ways. There is it legally adequate, which is one question, and another question is it adequate on the merits? And I'm assuming that during this session, we're not dealing so much with the merits, but with legal adequacy, but perhaps I'm wrong.
No, that's helpful, because I think that's exactly what myself and Mr. Clegg would like to get to the bottom of, is actually, are these objections actually to the legal adequacy and what is required under the legislation, or are they actually issues where there are obviously disputes that I've read in the evidence between the experts' positions on particular factors. So that's probably helpful in actually making that distinction, because those are two different things, and one, as I say, is about the merits and the or demerits of particular witnesses' evidence, whereas the other more fundamental thing is actually, is there a question about the adequacy in terms of the requirements of the Act and the rules. for the ES that's been provided.
So that's helpful. It indeed reflects the way that I had anticipated you would want to lead this discussion because of the distinction between those points. And just before we come to the individual elements, just by way of sort of overview, you'll have followed the chronology of this, which is that the concerns raised in the statement of case and then articulated in the post-pre-inquiry meeting note reflect the position at that time and before, in particular, the supplement to the environmental statement was provided, and we need to sort of update the position since then, and also the evidence that has been put in, the exchange of evidence. But the concerns that we have raised and continue to raise involve a combination of both types of adequacy concern. Some of those concerns as to legal adequacy have moved on since the position articulated post-PM, and I hope as we go through the items we can clarify which ones those are.
Perhaps, I mean, in light of that, Mr. Philpott, are there any on this list which have moved from a concern about legal adequacy into...
There are, and I was going to go through those in a moment if that's the most convenient way to present it. But if I before I go through the list, I'd just like to make a couple more comments about context to introduce those points, if I may. I'm in your hands as to whether you want to go through item by item just with me or by exchange, whatever you find most helpful.
Well, I think it'd be helpful to find out if there are items on here that you're no longer effectively challenging on a legal ground, because I'd much rather hear the evidence about those when we hear the detailed evidence from the respective witnesses.
Indeed.
And that has been helpful as part of this round table to actually identify those that if you're saying that there isn't an issue, or sorry, you're not challenging on a legal point of view, that just helps. We can shorten this agenda.
That's what I was hoping to do, sir. And I'm happy to go through those now myself, and then an opportunity for discussion and response.
You said you wanted to make a couple of brief points.
Yes.
Make a couple of brief points. Identify those, then I'll ask Mr. Cameron to come back.
That's fine. So I just want to make sure I'm doing the things in the order that you find helpful. So having identified that they have comprised, they continue to comprise to a certain extent both types of points, what I want to stress though is that the motivation for raising them, both types of points, is substantive rather than procedural. So this is not a case where we're seeking to achieve delay or to raise points for the sake of raising them. The concern in both respects, articulated through the evidence that we've put in, is as to whether there has been a proper and adequate consideration of the impacts of the scheme, both in terms of the selection of the route, but also in terms of the assessment of effects and the proposals for mitigation now. We're therefore less concerned, for present purposes, they will make it clear into which camp the concerns fall, because we're not seeking to take procedural points. Our concern is about the practical implications of what is proposed for the college. So we'll seek to clarify which things remain potentially legal issues and which are matters of adequacy. But our overriding concern is not about procedural matters or setting legal traps, it's about the substance. So if I then, against that background, go into the individual items. So first of all, on reasonable alternatives, this is an area where, whilst we maintain that the ES as submitted did not contain a comparison of environmental effects that was adequate, this is an area where we now say we're moving into a question of merit.
Thank you for clarifying that.
And that is that the issues that go to that are set out now in some detail in the proofs of evidence of both sides, which offer a comparison of the significant environmental effects of the alternatives which is a requirement of the rules. And in the light of that evidence, there is now, we say, sufficient environmental information for the two of you and in due course the Secretary of State to make a judgment on that point. So it then becomes a matter of merit.
Thank you.
Moving on to the assessment of significance of Clare Hall as a Grade 2 star listed building, whilst we maintain the position that the significance of Clare Hall as a Grade 2 star listed building was not adequately understood or assessed in the ES, and therefore as a consequence the assessment of impact of the scheme on its heritage significance was inadequate, for essentially the same reasons, whilst we say that the applicant's assessment remains flawed and unreliable, we recognise that with the more detailed assessment of significance from both parties that's come in via the written evidence, you now have a legally adequate level of information on this matter, and thereafter it becomes something that you'll need to make a judgment on.
Thank you.
Then the third matter, which is in relation to flood risk and measures proposed to avoid, prevent, reduce or offset likely significant effects. Now, Clare Hall maintains its concerns about the reliability of some aspects of the modelling, as the position statement that Mr Sinclair has put in explain that CD 2608 W33, and about the implications of the output in terms of policy compliance, but those are matters that go to robustness of the assessment and merits rather than legal adequacy. You'll have seen, however, that in section 5 of that position statement there is a lacuna identified in respect of information on downstream mitigation for the modelled increase in velocity, both in terms of identifying the mitigation and assessing its efficacy, and then in securing the provision of that mitigation so it can be relied on for the purposes of EIA and decision making. Now that is information which the EIA regime requires to be in the ES if that mitigation is to be proposed. We say that mitigation is required, and therefore if our position on that is accepted, that ought to be included within the ES. Now similarly, as I mentioned earlier, in our CD 952 at paragraph 3.1, we identified a further concern as to whether the landscape and visual impact of the proposed Binbrook Bridge had been properly assessed. Now, we have looked at the documents to which reference is made in ESA 2, and it refers to documents in paragraph 3.1.5 of ESA 2 to suggest where that requirement has been discharged. But having looked at that, that's the technical report, CD1 11.08.1, but that doesn't appear on the face of it to contain an actual assessment of the impact of the bridge. So that identified lacuna remains, and that is something which should be in the ES. We haven't seen that lacuna filled elsewhere. Now, just finally for completeness, you'll have seen our case includes and maintains an objection about the sequential test and whether it's been passed, but we regard that as a policy rather than EIA issue. So I treat that slightly separately, although it falls under the heading of flooding. Then operational noise, and as I've said, that includes both operational and construction noise and construction vibration. In terms of construction noise, our position is that the absence of adequate details of mitigation means that that has not been addressed in a way that meets the legal requirements for EIA. Now, you'll also have seen there's a dispute as to the likely noise and vibration levels and the need for further mitigation. Now, if further mitigation is accepted on our evidence to be needed, that would need to be described and its effects assessed. But for both construction and operational noise, the information that is required in respect of mitigation for it to be legally adequate needs to include an assessment of the likely effect of the mitigation on noise levels. And that's important so that there is full information to inform judgments by the decision maker on the following matters. First of all, the likely effect and efficacy of the proposed mitigation and the acceptability of the residual noise impact. Secondly, whether in the light of that, additional and/or more specific mitigation measures ought to be required and secured at this stage. And thirdly, any adverse environmental effects associated with the likely necessary mitigation measures themselves. For example, in this case, any impact there might be on the heritage significance of Grade 2 star listed building if mitigation needs to be provided at the receptor. What the EIA regime requires is that under Schedule 1 to the rules, paragraph 7, the ES must include a description of mitigation measures which explains the extent to which significant adverse effects are avoided, prevented, reduced or offset. So that's the legal manifestation of that common sense expectation as to what mitigation measures ought to deal with, and also that the description of likely significant effects needs to include not only direct effects but also those which are indirect or secondary, which would include effects arising from the provision of mitigation measures. Now, so in terms of...
So
yes.
Just so I understand you, what you're talking about is these sort of consequential effects is, for the sake of argument, I think it was mentioned in evidence, if it was argued that an acoustic fence was required in order to mitigate, are you saying that the implications on other aspects, such as significance of a listed building or landscape and visual, hasn't been...
Indeed. So
that's what you're saying.
It goes to three. Just drawing it into the specifics, but without getting too much into the detail. There are three broad things which seem to be at play. Taking construction noise as an example, one is a possibility of some sort of barrier between the noise and the receptor.
It's okay. I think I've
Yes.
understood what you're arguing is your sort of legal concern
Indeed.
about that point. Just to clarify that it includes what you're saying is an adequacy, the assessment of any consequential implications for mitigation.
Yeah.
So,
So there are some aspects of that which depend on the view taken on between the parties as to the need for additional mitigation, and there are the other aspects which you can see from the evidence, for example, on the extent to which the existing commitments on construction noise do or do not provide enough specificity to allow for those legal requirements to be met. But as I stressed at the start, we raise these points not for trying to take a procedural clever point, but because we're genuinely concerned about the substance of it and we want to see it addressed. But so far as the evidence is concerned, our evidence shows that there are complexities involved in providing additional mitigation which we say would be required at the receptor. Now, depending on what view is taken as to the need for that and what that might involve, it's easy to see how that may have secondary and indirect effects which would need to be considered, and if you or the Secretary of State took the view that more mitigation was needed, then that would need to be covered in the environmental information that is before the Secretary of State. So one can see that in terms of noise, there are still some legal issues that remain, but as I stressed, we're concerned about the substance rather than necessarily into which camp they fall. And the next heading is the assessment of in-combination effects. And the concern that we've raised here reflects the requirement in Rule 7A of the 2006 rules that the EIA must identify, describe and assess in an appropriate manner and then effects on various factors which are listed there, and then at the end of the list, and the interaction between those factors. So that's Rule 7A2. And our approach, as you'll have seen set out in the EIA note we put in, but also in the evidence, is that requires a holistic approach to looking at the interaction between the key impacts. So, for example, noise, landscape and visual impacts, the way they combine, their effect on Clare Hall as an academic institution, and also the way that interacts with questions of significance because of the particular nature of the asset here.
So sorry, Mr. Philpott, you saying that that's something that falls into what you think is a legal inadequacy? Are you saying that the applicant hasn't?
At the moment, I'm just explaining the nature of
Right.
the issue, because when one looks to ESA 2 to see what the applicant says by way of, well, actually this has been addressed, so there is a place in the ES where this has been addressed, and that is said to be, as I understand it, in the technical report 4, which is CD1 11.04, and the assessment of economic receptors, and there's a specific table referred to, but going back to that, the description of receptors in that table doesn't on its face include Clare Hall, and there doesn't appear to be anywhere in the ES where these various effects are brought together and considered holistically. And so we say that is on the face of it something which isn't there. It's not a question of whether what is there is adequate. It just doesn't do what we say is necessary here. And we say that is missing from the ES. It's not actually addressed in ESA 2 in terms of substance, but there is also a further point here, which again I don't want to go into too much detail, but one of the particular concerns we raise here about the way in which the various effects interact so far as Clare Hall is concerned and its future success as an academic institution of significant public interest is the ability to access Clare Hall for the purposes of service, maintenance and construction from the Rifle Range Road side. The evidence explains why that's important.
But hang on, is that an ES criticism?
It is indeed, because
why is that?
Because when you're looking at the effects and the interaction between factors, this is an effect on land use. It's plainly, therefore, something, if you're going to restrict the ability of an important socioeconomic receptor to function effectively, that is something which comes under the EIA regime. And the interaction between that effect and effects, therefore, on the ongoing functioning through restriction of access and restriction of the ability to develop, combined with effects which affect the academic functioning of the institution because people won't be able to study and concentrate in the same places in the same way, overall, the interaction between those factors comes together to create an overall effect on that receptor. And there needs to be a consideration not of these issues just in silos, but how they come together. And therefore that is the point we were stressing in the post-PIM note. And that is something which has not yet been acknowledged as something that needs to be assessed, let alone something where there is a proper assessment of it. So that is both a potential legal lacuna, but it's also something which goes very much to the merits.
Okay, well, thank you, Mr. Watson. But so from understanding from that, in terms of the first two items on the agenda about reasonable alternatives and the significance of the listed building, you're saying that there's no legal argument there. So
yeah, they go into the
we
they
don't
go
need
into
to
the
discuss
merits.
that further at this meeting. In terms of flood risk, I think there was just 2 points which you said weren't a sort of a merit issue. One was the downstream effects in light of the modelling, and the other was whether or not an appropriate assessment in terms of landscape and visual,
Yes.
etc., of the works for the bridge had been covered. I think in terms of noise, again, I think if I understood correctly, there was the issue that your objection includes construction, noise and vibration, which you're suggesting there is a legal issue around, but that's particularly focused on the mitigation and how that has been considered. And then in the in-combination effects, that is an area where you're saying that you have a legal objection to, and you made the point also about the interaction between elements which introduce this issue of the access to the property
Quite
for
right.
construction, etc. So,
That I hope is a helpful summary of where we've got to.
So I think that's a fairly comprehensive run through there. So in light of that, and just picking up on the things that we've sort of agreed, I don't think we need to get into detail. Mr. Cameron, there's quite a few things to come back on there. Are there any sort of general comments you want to make before we look at the items in particular?
What I was going to plan to do, sir, is to make some general comments on the approach to determining whether an ES is legally adequate, and then I'm only going to respond on the legal adequacy points, not the merits, because the merits will be dealt with in evidence, and I think that reflects the observations you've just made, hopefully.
Yes, please, that'd be helpful. Thank you.
So on legal adequacy, can I just, don't want to turn to too many judgments today, but can we just remind ourselves, if we go to core document 534, the Blewett case, subsequently endorsed by the higher courts, on the approach to be taken, because we need to know, or you need to know, sir, I'm sure you do, but I need to make plain what I say is the question that you're being asked to address, because we haven't really looked at this. And so if you've got CD 534 and you go to paragraph 41, please.
Is that the one that starts ground one in these proceedings?
Yes, sir. So before you make a final decision on this, you probably need to read from, I'm not going to go through it, but if you start at about paragraph 33, 34 and on, and it's really 34 identifies it, information capable of meeting the requirements must be provided. So it's not whether it's good, bad or indifferent at this stage, it's whether it's capable of meeting the requirements. And if we go to 41, I'm not going to read it all out, but if you, 41, about 4 lines down, the regulations, and these weren't the 2006 rules, but the principles are the same, should be interpreted as a whole and in a common sense way. The requirement that an EIA application as defined in the regulations must be accompanied by an environmental statement is not intended to obstruct such development. As Lord Hoffman said in North Yorkshire and Brown, the purpose is to ensure that planning decisions which may affect the environment are made on the basis of full information. And then this next bit, sir, is important. In an imperfect world, it is an unrealistic counsel of perfection to expect that an applicant's environmental statement will always contain the full information about the environmental impact of a project. The regulations are not based upon such an unrealistic expectation. They recognise that an environmental statement may well be deficient and make provision through publicity and consultation processes for any deficiencies to be identified so that the resulting environmental information provides the local planning authority with as full a picture as possible. There will be cases where the document purporting to be an environmental statement is so deficient that it could not reasonably be described as an environmental statement as defined by the regulations. Another case, was an example of such a case, but they are likely to be few and far between. So the effect of Mr. Philpott's submissions is that this is one of those few and far between cases. But that's as far as he has to go to show that it's legally inadequate. Now, it's also important to note that it's not just the environmental statement that can be considered at this stage, because information provided during the inquiry process also has to be considered. And the authority for that proposition is a case called Davies, which we've got at core document 536. So if I can trouble you, sir, just to turn that up. And if you go to paragraph 47, if we just get to the nub of the point on page 19 in the PDF.
That's the one starting for these reasons.
Correct,
I do not
sir.
accept, yeah.
I do not accept the novel proposition that if additional environmental information, i.e. environmental information that is in addition to that which was contained in the environmental statement and the responses thereto under the regulations, is produced at an inquiry, that additional information either should not be considered by the decision taker or should not be considered by the decision taker unless it has been subject to the same degree of publicity and consultation as the information in the environmental statement. So when you're considering this question, you can consider the information put in the proofs of evidence. And Mr. Philpott fairly accepts that, and he says an example of that was in relation to impact on the significance of the heritage asset. So we're not just looking at the document which bears the badge environmental statement, we're looking at a holistic, common sense way, is have you got the necessary information to make the decision? Those are two separate points. How much do you need to be an environmental statement? And secondly, that it can be supplemented by the evidence in the proofs of evidence and other material. And the third point that I make, general point, before coming to the details, is this, that if there is some inadequacy, and we say there isn't a legal inadequacy, the Secretary of State could, and we assume would, have made a request for further information, and that, under the rules which we're operating under, comes under Rule 17(1) of the 2006 rules, which we've got at core document 518. So you'll be familiar with this provision in the planning context. It's probably a Regulation 25 request, I think. Keep on changing the numbers. But in these rules, it's Rule 17(1), where in the opinion of the Secretary of State, the applicant's environmental statement should contain any additional information in order to constitute an environmental statement. For the purposes of the application in question, the Secretary of State shall direct the applicant to supply that information. Well, point one is the Secretary of State has not come to that conclusion as yet. And secondly, point two, look at the very high bar. It has to be so deficient that it isn't an environmental statement. That's Blewett's, Mr. Justice Sullivan's, few and far between. So, is this one of...
Can I just interrupt? Just to clarify a point there, Mr. Cameron.
Yeah.
I think you said it when you approached number 3. So is your position that actually you disagree with everything that Mr. Philpott said, and that there are no legal deficiencies, for want of a better word, as you see it in?
I wouldn't be so rude as to say I disagree with everything that Mr. Philpott says.
I meant the context of this particular discussion, not anything wider.
Yes, sir, we do not accept that it's legally inadequate. It's not one of those few and far between cases, and I'm about to try and explain why I say that. So if we, but the reason for that rather long introduction is this: the question you're asking, is it so bad as to not amount to an environmental statement? That's the question. And so we take, so we got flooding, we've got construction noise, and we've got in combination effects. So on flooding, and I'll be told if I'm wrong by Mr. Southern, but the broad point is this, that Clare Hall's experts think that downstream mitigation is necessary and therefore it should be assessed. But the assessment in the ES, and this is, you then come to a merits point, is it wrong or right, but it doesn't go to legally adequate, is that such mitigation is not required. So if that is the assessment in the ES, what is it that's deficient in the ES in a legal way, as opposed to a merits point? And so that is also the answer to the landscape impact point as well. So we can, at a later stage in this inquiry, we can have a debate about whether downstream mitigation is required. But if the position is not required, then there's no deficiency in an ES in not assessing something which is not required. Now, if the objector says it is required, they can explain why it's required and what's required, and then you can take that into account in assessing the overall environmental information. But that's the end of that point for now. On construction noise, and I'm going to take these all pretty briefly, on construction noise, the essence of the assessment in the environmental statement and in the evidence from the applicant is that measures taken in accordance with a code of construction practice will be sufficient to mitigate the noise effects. And there's some reference in the evidence, I don't go into the detail, about operations being limited for a certain period, and therefore they fall within a certain category. And so, sir, again, the objector may disagree that the Code of Construction Practice will provide adequate mitigation, but that is the view of the applicant's experts. If that is the case, the ES is legally adequate, and there's no need, for example, for screening on site. So no need to assess something which is not considered to be necessary. I mean, if you had to assess all the things which you didn't consider to be necessary, but somebody else might consider to be necessary, it would never end. And that is not the point of the environmental assessment process. Now, in combination effects. Now, here, sir, I'm going to ask you, if you could please, to take up the main chapter of the ES. So that is CD 110.1. And see what I've done with it. I don't know what I've done with it. But if you can take that up, sir, and once you've got it,
Yep, I'm there.
which I haven't, but anyway. If you go to paragraph 2.4.7 on page 19,
Under combined effects, got that? Yep.
yes, and there, sir, if you go at 2.4.7, sorry, I'm just, there we go. What it says is, this is where combined effects are considered. The environmental assessment has considered impacts and effects in the round, taking account of how separate impacts from the scheme might cause an overall combined effect. So doing exactly what Mr. Philpott says it should do. For example, noise, traffic and visual impacts at one location could result in a general combined disturbance effect for local residents, or several separate impacts on hedgerows could result together in significant depletion of habitat, and the ES referred to these as combined effects. So addresses the principle of it, and then if you go to page 134, and you'll find an 11.1.3 under Chapter 11, Cumulative Effects, and it says likely significant combined effects would be described as relevant in Chapter 7 to 10. However, none are predicted to occur. Now, others may disagree with that assessment, and Clare Hall obviously do, but it can't be said that this is a legally inadequate ES, because it does actually address the point, but the conclusion is, again, that none are predicted to occur. So if none are predicted to occur, they can't be described. So I just check that I haven't left anything out. But Mr. Henderson says I have, and he's going to deal with that.
No, so the second point on the flooding was about Binbrook Bridge. Well, we haven't looked at the landscape and visual effects of that. The answer to that is we have. Let me give you the references. ESA 2, which is CD 110.07. There's a specific section on this on PDF page 11. So it's ES 110.07, PDF page 11. It's paragraphs 3.14 and 3.15. That cross-refers to another document which I can give you the references to in a moment. I see you're turning the pages up. But the short point, so if you've got 3.14 there, just look at the final sentence of 3.14. No likely significant effect. We can come on to whether that's the right judgment or not, but it's clearly a judgment's been reached within ESA 2. The support and reason for that in the next paragraph tells you where to look. That gives you a reference to Technical Report 8, CD 111.08.1, and I'll just give you the headline point there. That includes an assessment of the stream. The stream as defined in that report, section paragraph 1.1.2, and indeed 3.1.2 includes that bridge. So this is a technical report that has looked at the stream, including expressly that bridge, and has looked at the relevant receptors, and you get them here. It's LCAB3 and TCA2. And to give you just a few more references to make that good, you will see, for example, table TR841. So that's table TR841, which is in that document at PDF page 30. That includes both of those areas. To give you, that's for the construction effects. And if you want to understand about the long-term operational effects, same document, table TR843, table TR843 on PDF page 40. And the stream is assessed, including the bridge on those relevant receptors in those tables. Whether that's right or wrong, different question. But is the Binbrook Bridge looked at? Yes, it is, sir, and that's the route through for those references.
Thank you. I mean, that's very helpful to understand the two parties' position on that. Just before I perhaps ask some other questions, is there anything anybody else wants to raise at this stage? I can see Mr. Philpott, you want to. Nobody else? Ms.
Okay,
Philpott,
so I'll try and keep this brief,
yeah.
because I don't want to prolong the thing unnecessarily.
If I can just sort of preface this, I mean,
Yeah.
I can understand from listening to both of you that there's disagreement there that's not going to be resolved in a meeting. That's not the purpose of this round table anyway. It's to help myself and Mr. Clegg just understand what the arguments are and what the positions are. So Mr. Philpott, yeah.
And I'll keep it brief with that in mind, sir. In terms of points of approach, there's an important distinction to be kept in mind between the approach that is taken by the High Court, where it is dealing with a challenge to the lawfulness of a decision based on an allegation that the ES was lawfully inadequate, and on the other hand, a situation like the one we have at present, where a decision maker is faced with an exercise of judgment and discretion as to whether what has been put before them is adequate, including whether what has been provided in purported compliance with legal requirements is in substance compliant with them. And so, for example, if one looks at the provision in Rule 17 that was referred to by my learned friend, there are two elements of it. The first paragraph applies where, in the opinion of the decision maker, the ES should contain any additional information in order to constitute an environmental statement for the purposes of the application in question. Where that opinion is formed, there is a legal duty to direct the applicant to supply that information. And then in paragraph 2, without prejudice to that paragraph, when considering an application, if the decision maker may direct, so a power to direct the applicant to provide such further information as may be specified concerning any matter which is required to be or may be dealt with in the environmental statement. So if, for example, the decision maker forms a judgment that what purports to be compliant with a legal requirement in the ES is in substance not required, not just a decision as to whether it goes far enough, but if it just doesn't in substance do it, there is a legal duty. But there is also, even if it falls short of that, but it is regarded as being plainly inadequate in order to provide the information needed, a power to direct. And the points that we have made, and we've identified which particular parts of the EIA regime we say have not been dealt with, either at all or in substance, are matters which, if you accept the force of our points, clearly engage Rule 17, either 1 or 2. For our purposes, because we're concerned about substance, not form, we really don't mind which of those it is, or indeed if the matter is dealt with voluntarily by the applicant. We simply want to make sure that there is enough information that all of these things are dealt with. So with respect to my learned friend, it's a slight distraction getting onto questions of what would be the test at legal challenge. What we're here concerned with is whether there are real and important gaps, not just whether something is dealt with adequately, but whether there are gaps. And for our purposes, therefore, those matters of approach are slightly beside the point, because what we're interested in is the substance rather than the form. That, of course, is a power and a duty which arises and applies throughout the process. It's not, therefore, a point where if the Secretary of State hasn't exercised that power hitherto, it no longer has any ongoing application. It does, it applies throughout the process. And so far as the individual topics are concerned and what is said about those, I sought in my introductory comments to summarise the particular concerns that we have had when seeking to trace through the references that were provided in ESA 2, such as those that were repeated earlier by my learned friend in respect of in combination effects and in respect of the landscape effects that were explained earlier, we did that and we found there was in fact no substantive assessment. So, for example, in relation to the landscape impacts of the Bin Brook Bridge, the words Bin Brook appear 4 times in the document to which reference is made. In none of them is it in connection with an assessment of the bridge. We simply couldn't find one. So we've sought to read carefully what's been put, but nevertheless, there are some areas where we think that there is still an issue of legal compliance in addition to those which have moved on to the merits. And we've tried to be selective in those which we say still fall under that category, but nevertheless there are still a few.
Okay, understood. I'll let Mr. Cameron come back on those points.
So it is right that the law that I cited to you deals with challenges to decisions made by a decision maker on adequacy of the ES. But there's also no doubt that the principles apply when you are making your judgment as to the adequacy of the ES. And the question is it so deficient as not to be an ES? And then, sir, the question becomes, well, what is it that the objector, if you were to accept the points that the objector makes, what are they asking you to do about it? And it could be that they're asking you to make a request for further information. And if that's the case, I would have thought that, or I would submit that they need to identify what it is that they say should be required as further information, or perhaps they are just saying these are matters of substance which must be dealt with during the course of the inquiry. So I think if they are saying that a request for further information should be made, they need to identify the precise terms in which that request is to be made. But, so there are 2 answers. One, the test is still the test I put to you, which is it so deficient as not to amount to an ES? We say, for the reasons that I've given, no, it is sufficient. But if you were to be against us, we also say to the objector, what is it that you're asking the inspectors to do, and what are the precise terms of the information that you request? Because if they were able to identify that, it may be that that can be dealt with in evidence. But the substance of the submission is you should find that the ES is adequate. There's no justification for making a request for further information. And if you would find it helpful for various points to be dealt with in evidence, you may wish to indicate that.
Okay, thank you, Mr. Cameron. I think this is a good time to take a short adjournment. Do you think we?
Possibly, yeah.
Yeah.
Yes.
We'll adjourn shortly, and then we'll resume at 4 o'clock. Not only to consider what you and Mr. Philpott have said, that there's also something else we need to...
There's another matter cropped up which Mr. Underwood and I need to have a discussion about, and then we'll come back on that at 4.
So, yes, so the inquiry is now adjourned, and we'll resume at 4 o'clock. Thank you very much.
Thank you.
resumed. Thank you very much, Mr. Philpott and Mr. Cameron, for explaining your respective positions. I don't think I've got any more I need to get. As I mentioned before, it's clear what the two parties' positions are on that. Just before I sort of bring discussions to a close, I think, Mr. Clegg, you had one particular question.
Thank you. Yes, just a question for you, Mr. Philpott. Given what we've heard so far this afternoon on this, is it the view of Clare Hall that there is an environmental statement?
So the question is whether the documents that comprise the environmental statement include all of the elements that must form part of the environmental statement under the rules. For the reasons we've explained, some of those elements are missing, and therefore in terms of the legal question, do you have an environmental statement that contains everything that needs to be contained in order for it to be an environmental statement as defined? No, there are some elements which we say are missing. If it helps, what I was going to suggest in light of the discussion, and I had a brief discussion with my learned friend Mr. Cameron over the adjournment, we think it may be helpful if we put in, following this roundtable session, a written note which explains our view in terms of the legal approach and seeks to set out in writing, with references, the points that we've made. Partly, I hope that will help in terms of any note and recording of our position following today, but also we think it may be helpful both for the inquiry overall, but also for the applicant to see it in effect of a shopping list, an up-to-date position statement, as it were, as to where we are now, so that they can form a view as to whether they wish to supplement any of the information that is currently before the inquiry. Because if they do, then it will obviate the need for you to form any judgment about whether to put in a request under Rule 17. If they choose not to, then you may want to revisit that matter. But we think the first point that would be helpful is for us to put our position in writing so that the applicant first and of course you and your colleague can take a view as to what, if anything more, might need to be done.
Okay, Mr. Philpott, that may be helpful. Mr. Cameron, do you wish to respond?
No, sir. We've made our submissions. When we've seen the shopping list produced by Mr. Philpott,
Yes.
we'll consider it.
Yes.
And take a view on whether we should provide further information. But at the moment, and our position remains as it is, that it's a legally adequate ES. The objectors may not like some of the judgments, but given the judgments, it is legally adequate. There's no need to make a request for further information. But if this list comes in, we will of course consider it.
When do you think the applicants and ourselves would be able to see this list?
So we'll produce that as soon as we can, but if I set a deadline, then we'll do it within a week, and hopefully we'll get it in sooner than that. But that would be, I'd need to check the list with our consultants, but that ought to give us plenty of time to
So
do
if
that.
we say end of play next Monday?
Yes.
Okay. Thank you. Right. I think unless anybody's got anything else they want to raise on this particular point, Mr. Barker.
Sorry, just very briefly, but I'm sure you're aware of this, but just to flag up, we have complaints about the ES. They don't fall into the same category as the complaints made by Clare Hall. They are trenching complaints, but they will all come out in the process of the giving of evidence consistent with what you have said and the approach that's been taken. So I just wanted to flag that up.
That's quite understood. As I said at the start, the understanding was where there are issues, and in fact, you're not the only parties who have actually raised concerns about the ES, but it has been in terms of, as I think the discussion's gone, the merits of the argument sort of area rather than a sort of a legal sort of content objection. So that's understood. Well, in that case, I'll bring this round table to a close. Thank you very much for everyone's contributions. And next, there's a procedural matter we need to raise, and I'll hand over to Mr. Clegg for that.
Coming back to the point that I raised when the afternoon session resumed, which is whether or not anything had been heard from Tipu in connection with the question of publicity notification for the inquiry. We have been copied into correspondence, which I think the applicant will be aware of. I'll read it out. It's a short email. I've consulted with legal colleagues. This is from the Senior Planning Officer in the Transport Infrastructure Planning Unit at the Department for Transport. I've consulted with legal colleagues, and unfortunately, in the light of Adam's email today confirming that Rule 13.6b of the Transport and Works rules have not been complied with, the Secretary of State has no option but to advise the appointed inspector to postpone the public inquiry for the Cambourne to Cambridge Transport and Works Act proposed order application until advertising requirements have been met. I've copied the programme officer, so she's also aware, and will write to all interested parties accordingly today. Now, although the email uses the word advised, a letter is going out in those terms. So we will obviously comply with that, what is in effect a requirement from the department in terms of the inquiry. Mr. Cameron.
Well, so as you know, my submissions this morning were made, A, on the basis that you should defer any decision until TIPU had pronounced on whether they would make a direction that we didn't have to comply with the 13.6b requirement. And then I asked you to make your own mind up on this decision for the reasons that I advanced. And I argued that if one looks at the reason behind the rule, and then you looked at the substance and the prejudice or lack of it, it would be proper to continue. Now, I know, sir, you've now received this from the Transport Infrastructure Planning Unit, but the decision is still for you, and that email does not address the submissions that I made on the principles to be applied. Now, I know I'm trying to push a stone up a hill, or probably a hill, but it's nonetheless a decision for you to be made on the principles that I outlined. And so we would request that you do consider the submissions made, you consider the reasons for the rule, you consider the other means of advertising, and you consider prejudice. But sir, you've indicated the deference that you will pay to that advice, but it is expressed as advice.
Well, the first part is, Mr. Cameron, the last short paragraph is not. It's quite clear that people are writing out the event.
Yes.
So we don't want to be in a contradictory situation where we decide to continue and a letter is going out from TIPU to parties saying that the inquiry is postponed.
So we then haven't had a ruling on the submissions that I made this morning at all. They weren't, TIPU haven't considered them, you haven't made a ruling on them, and I appreciate the difficulty, sir, but we have made submissions, we have identified the legal position, and you do have a discretion. And yeah. Sorry, I'm just, yeah. So I already said this, but I've made submissions on behalf of the applicant. You very properly deferred consideration of them. TIPU have not heard those representations, and they seem to have proceeded in writing without having heard those submissions and without giving us an opportunity to make them. And so and the submissions were hopefully clear and identified why prejudice was not caused by this failure. And the approach that TIPU has taken appears to be entirely contrary to the legal position, which is that you should look at the purpose of a procedural rule and whether prejudice is caused, and not just take it as an absolute rule. They seem to have taken completely the wrong legal approach, which is not consistent with the authority that I put before you, the A1 Properties case. They have taken a rigid category-based approach to and not looked at the consequences. So what I would ask, and I'm going to try and make a practical suggestion, is that you adjourn, but not for a lengthy period. We could adjourn, say, to Thursday or to tomorrow morning, and that would give us a chance to make representations to TIPU, which would be along the lines that we put to you, or if you feel able, you make a decision yourselves. But we would at least request the opportunity to make representations to TIPU before they take some decision, and we can do that straight away. We can submit them tomorrow, and then either they make a decision or you make a decision, but the decision is actually yours.
Well, Mr. Cameron, one thing we had already decided was that we intended to proceed with the site visits tomorrow morning, because they're essentially outside the inquiry proper. That would give you any time you may have this evening and tomorrow morning to put the points that, as you say, TIPU are unaware of what Mr. Underwood and I have heard. On that basis, I wonder, do you think an adjournment until tomorrow afternoon would be too soon?
Well, we would certainly get our submissions into TIPU before then, but I don't know when they'd make a decision on it.
Yes. It's not necessarily making a final decision, is it? It's a question of whether action is taken in connection with writing out, as they say in this email.
Yeah, I think that's one of the issues, is that the information we have at the moment is that they are intending to write to all interested parties today. So, I mean, as Mr. Clegg said, I think we're of the mind we would be adjourning at the end of today anyway to carry out the site visit tomorrow morning.
Yes, we'd already decided we were going to do that in any event, so I think we want to proceed on that basis. Although reading the email as it is talks about advice, I think the way it's written severely limits discretion available to Mr. Trumpet and myself, irrespective of the arguments. I think the arguments that you are concerned about, you need to put to Tipu. I think on that basis, I think we would suggest that we proceed with the site visits, adjourn until the advertised time of 2 o'clock, and we'll see what, if anything, has come back by then.
Yes, and I'm conscious that I have witnesses who are due to come at 2 o'clock. Mr. Parker is not cross-examining, I don't think, but he is cross-examining on Mr. Whitehouse, who's the second witness. So I'll have to take a view on whether those witnesses are in attendance.
Yes.
Yes, unfortunately, I think.
Well, it's not your difficulty.
I can give you an instruction one way or the other on that.
Yes, you just have to take a view on that, Mr.
Yes.
Cameron.
It may be that, and I'll talk to Mr. Parker in a moment, it may be that if I do go ahead, it may not be with Mr. Freeman, but I'll talk to Mr. Parker afterwards.
Okay.
Just to give him notice.
Thank you.
Jeff, did you?
Nothing else to
Yeah.
That's it.
That apart, which was unexpected, is there anything else anybody wishes to raise before we adjourn for this evening? Mr. Parker?
No, just to confirm that so far as you're concerned, you will expect to see us back here at 2 o'clock tomorrow unless we hear by email from you otherwise.
No,
but that's the
no,
expectation.
we will be back here at 2 o'clock, but we may be continuing with the inquiry or we may not at that point.
I think that's it. The parties have obviously got to understand there's a possibility that we might resume for a very short period.
Yes.
Or we might not. So, sorry, we can't give more certainty than that at this moment.
Okay, well, if there's nothing else, the inquiry is now resumed, and remember when we convened.
I think you mean.
Sorry, yes. And when we do resume at 2 o'clock tomorrow, it won't be in here, it'll be in the Magdalen room on the other side of the hotel. Thank you.